Anti-dumping is one of the most important and most frequently used ways in which governments under the WTO system can impose new duties on imported products. So I want to lay out some of the criteria that are in WTO rules and also to talk a little bit about the U.S. institutions that implement these in practice. So they are subject to WTO obligations. Now, under Article 6 of the GATT, countries can impose anti-dumping duties, that is to say, duties on particular foreign firms beyond the MFN bound rates if two things occur. One, the foreign products are dumped, and that is to say, the domestic government does an investigation and shows that foreign firms are either pricing below the production cost in the home market. And when I say pricing, that does say the price in the export market. So, for example, if the United States is taking a look at Japanese imports, if the Japanese are pricing below their in the United States below the cost of production in Japan, that's dumping. It's considered unfair trade. Or if the Japanese are selling in the United States below what the Japanese charge inside the Japanese market, that is also considered dumping. So this is the cost-based definition of dumping. This is the price-based definition. So that's one criterion. The other criterion is that these dumped imports have caused material injury to a domestic industry producing the like product. So if these two things can be shown, then by the domestic government, then the WTO rules allow the domestic government to impose these special duties. Now let's talk about which groups are involved in doing these investigations in the United States. Once again, this is not done by the WTO. It's done by the domestic government subject to WTO disputes settlement. So in the United States, the dumping investigations are done by the U.S. Department of Commerce. It's actually the Import Administration. And they will look at a petition that is filed by a U.S. domestic industry complaining about foreign practices. And the U.S. Department of Commerce will do an analysis of either of these two criteria. The default being that they try to see whether or not the foreign firms' prices inside the United States are below their home market price. So that's the default. If they don't have enough, if there's not enough sales in the home market, then they'll go to the production cost method. Now, one of the things that ought to be very clear about this is that in order to do this analysis, you need to get some information about the home market price. And that requires the Department of Commerce to send out questionnaires to the foreign firms, asking them essentially to open up their books to Department of Commerce investigators, or looking at their books in order to determine their production cost. Now, this can be controversial. A foreign firm gets a questionnaire with a pretty tight deadline from the Department of Commerce saying, you've got to let us look at the inner workings of your firm. Now, any information provided by the foreign firm is under strict privacy rules by the U.S. government. They can't share that with the U.S. domestic competitors. Nonetheless, many foreign firms may hesitate to share that information. And in those instances, the U.S. The Department of Commerce would use what are so-called facts available, which are typically the allegations by domestic firms about foreign behavior. This is basically to encourage competition by the foreigners to provide the information that's required by the Department of Commerce. So, if the Department of Commerce says yes, that there is indeed dumping according to one of these criteria, that fulfills one aspect of the WTO rules, but that's not enough. There also has to be a determination that these dumped imports cause material injury to the domestic industry. And that investigation is undertaken by the U.S. International Trade Commission. The ITC is a quasi-judicial independent agency that has 6 members that are nominated by the president, approved by the Senate. No more than 3 can come from any particular political party. So they're really seen as a kind of court, kind of a Supreme Court, if you will, for making decisions. I shouldn't say Supreme Court because they don't make the. These cases can be sent to a Court of International Trade, but it's essentially an impartial body that is analyzing the evidence about the domestic industry in order to determine the presence of material injury. So they're going to be looking at employment effects, at profitability, production, investment, various measures that indicate that a domestic industry is having problems. If the ITC says yes, and the Department of Commerce says yes, then duties are placed on the foreign firms' products. Now, one thing you'll note here is that I haven't mentioned any role for the Congress or the President. And that's quite deliberate. This anti-dumping process is really designed to be a much more of a bureaucratic than political process. The politicians are not involved in the decisions of individual cases. Instead, very detailed rules set out by the Department of Commerce in making its decisions, the ITC making its decisions. Congress doesn't pass a law to impose anti-dumping duties. The President doesn't make the final decision about anti-dumping duties. These 2 groups do. Now, of course, the President's nominating the members of the ITC. The President is choosing who are the administrators at the Department of Commerce. And, of course, Congress passes the laws. But as a practical matter, on individual cases, this is supposed to run in a non-political way. Now, the upshot of that is that there can be very awkward circumstances where duties will be placed even if it's politically difficult. So, for example, there was a case involving imports of shrimp from Thailand right after the tsunami back in the 2000s, and there was nothing that the President could do to prevent the imposition of the tariffs because these 2 agencies had said the Thai shrimp had been dumped in the United States. So a very awkward circumstance. Now, the other aspect of this is how long these are supposed to stay in place. Essentially, 5 years minimum, and then they reassess whether or not dumping or injury would be likely to occur. So, but those sometimes can be renewed multiple times. So, dumping, very common procedure in the United States. And these are the two agencies that are involved. And once again, the president has no way to forestall the imposition of tariffs in the case of anti-dumping duties. That is done if these two groups say yes, and that is consistent with WTO obligation. Are we talking about involving anti-dumping investigations in the United States? So from 2000 to 2012, the ITC ruled affirmatively in 169 anti-dumping cases, said no about 61 times. It's notable that the Department of Commerce ruled in the affirmative 183 times and only had one negative vote. So broadly speaking, the ITC is the agency that's going to say no in these investigations. Moreover, the average dumping margin, that's the duty that is placed on individual foreign firms, is 97% for this same time period. So let's be clear about this. When there's an anti-dumping duty, the duties are placed only on particular firms from particular countries. So that 97% is the average overall. And the average U.S. tariff is about 4%. So you're talking about really potentially eliminating the ability of a firm to operating inside the United States if they have similar costs to everybody else and face 100% tariffs. Moreover, the Chinese have become to be particularly targeted in anti-dumping cases. 67 of those cases, from 2000 to 2012, involved Chinese products. Only 8 negative decisions by the ITC, 0 negative decisions by the International Trade Administration, so department unit within the Department of Commerce. And the average tariffs or duties imposed on Chinese products in anti-dumping cases was 154%. So these can be quite onerous tariffs that are placed on the foreign products. The other thing I would say, other jurisdictions have different approaches to the final decision making in an anti-dumping case. Most notably, the European Union has a public interest clause, which means at the very end of the process, after the dumping and material injury decisions have been imposed, the Council of Ministers at the European Union level makes a decision to approve or not approve the anti-dumping duties. This is particularly controversial recently in the case of anti-dumping duties against solar panels from China, where there was great controversy within Europe, especially the Germans who didn't want to impose duties and other countries that did. That kind of controversy simply doesn't take place in the United States because there's no decision making by politicians. So a solar panel case in the United States goes through with, there may be opposition, but there's nothing that the president or Congress can do about it.